Hello and welcome to today's episode of You and the Law. I am your host, Gentle Queen. In today's episode, we will be looking at the fair hearing provisions under the 1999 Constitution of the Federal Republic of Nigeria as amended. The court gave us another interpretation of the concept, with respect to when an accused person elects to defend himself in a criminal trial. Our case study today will also revolve around the National Drug Law Enforcement Agency. I am certain some of us are aware of the powers conferred on the National Drug Law Enforcement Agency by its establishing act. Some of these powers includes the power to identify, trace, freeze, confiscate or seize proceeds derived from drug-related offenses, or property whose value corresponds to such proceeds. The Act also empowers the agency to take such measures, which might require the taking of reasonable precautions, to prevent the use of ordinary means of transport for illicit traffic in narcotic drugs, including making special arrangements with transport owners, etc. It is in furtherance of this duty and functions imposed on the NDLEA by the Act that most times you see them stationed by the road. Let us now follow the screen to see how some persons were prosecuted for trafficking drugs without lawful authority.
On the 10th day of January, 2016, in the early hours of the morning, officers of the National Drug Law Enforcement Agency were stationed along the Abuja Expressway when they noticed a bus approach them. They suspected they were transporting illegal substances and asked them to stop.
I am happy there is no suspicious case today. Yes. But do you see that bus coming? It looks suspicious. Okay, let us check it out.
My friend, we will make money from this deal.
Yes, my brother. I can confidently say that I am now a big boy. All my suffering will finally come to an end.
Are you telling me? I have told Bimbo to start preparing for our marriage. We will paint the town red.
Baddest. You are a bad boy. Wait! Do you see the NDLEA officials down there?
What? I am not stopping for anything. Better put on your seatbelt.
The officers signaled the driver to stop, but he refused to stop. Then they started a pursuit.
Do not let them escape, sir. They will not escape. Not while I am driving.
What did I tell you? What do we do now?
Don't ask me any question. Did I not tell you to stop?
Let us give them something. These officers look hungry. They will collect it.
Good suggestion. You go and do the talking and negotiation.
Officer, please, I beg you. We have money. We will give you money. Any amount of money, sir.
If you like. Beg till thy kingdom come. We are arresting you. The two of you will have your day in court. That is final.
The two men were arrested and taken to the NDLEA office. They made confessional statements admitting their role in transporting illicit drugs. On the 8th day of March 2016, they were arraigned at the Federal High Court Abuja for conspiring to transport 42 kilograms of cannabis sativa, otherwise known as Indian hemp, without lawful authority. And the case began.
Call the first case.
Ibrahim Atamu and Danlami versus the Federal Republic of Nigeria, 2020, 2 NWLR, Part 1707, 129. My lord, the accused persons are in court.
Please enter your appearance.
May it please my lord, I am Bassie West. My appearance is for the prosecution.
Where is the counsel for the accused persons?
My lord, accused persons have no legal representation.
Where is your lawyer?
The accused persons have elected to defend themselves, my lord.
Okay. Read the charge to the accused persons.
That you, Ibrahim Atamu, and you, Danlami, on or about the 10th day of January, 2016, without lawful authority conspired amongst yourselves to transport 42 kilograms of cannabis sativa, a narcotic drug, and thereby committed an offense contrary to and punishable under Section 14b of the NDLEA Act. How do you plead? Guilty, or not guilty?
I plead guilty.
I plead guilty, my lord.
My lord, accused persons plead guilty to the charge.
Counsel for the prosecution, what next?
As the court pleases. My lord, I apply to tender their confessional statements wherein they admitted the offense. The court admitted the confessional statements and marked them as Exhibits B and C.
My lord, I also tender a sample of the substance they were conveying before their arrest.
The substance they were transporting was admitted in evidence and marked as Exhibit D.
Upon their arrest, my lord, the substance they were conveying was tested in a laboratory. The test confirmed that what they were transporting was cannabis sativa. I apply to tender the result from the lab.
The lab result was admitted in evidence and marked Exhibit E.
I urge the court to convict the accused persons on their plea of guilt, in line with Section 274 of the Administration of Criminal Justice Act, 2015.
Mr. Ibrahim Atamu and Mr. Danlami, do you confirm that everything the prosecution said in this court is the true state of things?
Yes, my lord, I confirm them to be the truth.
Yes, my lord, they are truth.
In that case, do you have any other thing to say to the court?
Forgive us, my lord. We actually thought they were armed robbers. That was why we ran. Temper justice with mercy. We did not know that what we were carrying was Indian hemp. Forgive us, my lord.
We are sorry, your lordship. We did not know they were law enforcement officers. That is why we did not stop when they asked us to stop. Temper justice with mercy, my lord.
After their oculus, that is, a plea of mercy, the court delivered its judgment.
Section 274(2) of the Administration of Criminal Justice Act provides that where an accused pleads guilty to an offense with which he is charged, and the court is satisfied that the accused intends to admit the truth of all the essential elements of the offense for which he has pleaded guilty, the court shall convict and sentence him, or make such order as may be necessary, unless there shall appear sufficient reason to the contrary. In the circumstance and on the strength of the evidence adduced by the prosecution, and the guilty plea of the accused persons, I hereby convict the accused persons on the offense charged and sentence them to 15 years imprisonment respectively.
Dissatisfied with the judgment of the court, the accused persons appealed to the Court of Appeal. The Court of Appeal dismissed the appeal. They made a further appeal to the Supreme Court. The issues before the Supreme Court were 1. Whether it was right for the Court of Appeal to have affirmed the decision of the Federal High Court, convicting the appellants, even when they pleaded that they did not have knowledge of what they were conveying. 2. Whether it was right for the Court of Appeal to reject the statutory and constitutional right of the appellants to fair hearing, on the ground that it is not the business of the court to make sure that a party takes advantage of the environment or atmosphere by involving himself in the fair hearing of the case. The counsel for the appellants argued,
My lords, I submit that it was wrong for the Court of Appeal to have affirmed the decision of the Federal High Court, even when the appellants stated that they did not know that what they were transporting was Indian hemp. With respect, my lord, I submit that the mens rea of unlawful possession was not proved by the prosecution. During elocutos, my lords, the appellants also stated that they ran because they thought the NDLEA officers were armed robbers. My lords, they have a right to be scared for their lives. Secondly, my lords, I believe that since the appellants gave reason which ran contrary to their plea, the court ought to have changed their plea and ask them to seek legal representation or provide one for them. I refer my lords to Afoknwam v. State, 1995, 3 NWLR, Part 384. In addition, my lords, the appellants were not given fair hearing and the crime was not proved against them. More so, the procedure for the arrest of drug suspect as laid down in Ugwaaniya v. FRN, 2012, Lapalra 7817 SC was not followed. I humbly urge your lordships to allow this appeal and set aside the judgment of the lower court.
The prosecution, on the other hand, maintained that it proved its case as required by law.
My lords, the confessional statement of the appellants, wherein they admitted the crime, was admitted in evidence. The prosecution proved its case. I urge my lords to dismiss this appeal.
After listening to the arguments of the counsel on both sides, the court delivered its judgment.
In a charge of unlawful possession of Indian hemp under Section 19 of the National Drug Law Enforcement Agency Act, 2004, the prosecution must prove beyond reasonable doubt these essential ingredients to wits. 1. That the substance was in possession of the accused. 2. That it was knowingly in his possession. 3. That the substance is proved to be Indian hemp. 4. that the accused was in possession of the substance without lawful authority. The time-honored principle of law is that an accused person is presumed innocent until he is proved guilty. The burden of proving the guilt of the accused person rests squarely on the prosecution, and such burden does not shift. However, even though the burden of proof of the guilt of an accused person lies on the prosecution, where the prosecution had adduced adequate evidence, which shows that the accused actually committed the offense charged, the burden of proving that he is innocent shifts to the accused, in view of the provision of Section 138(3) of the Evidence Act. Whereas in the instant case, the prosecution has proved the ingredients of the offense against the appellant, and the appellant himself pleaded guilty to the crime, he has automatically lifted away the burden of proof on the prosecution, which is shifted on him to prove his innocence. The prosecution tendered the confessional statement of the appellants, and other exhibits to prove the ingredients of unlawful possession of cannabis sativa. Their confessional statements and the substance recovered from them were admitted in evidence. Rather than prove their innocence, the appellants confessed and pleaded guilty to the commission of the crime, thereby obviating the necessity of any defense or innocence in their favor. The defense that they did not have knowledge of what they were conveying has been watered down by their confession and plea of guilty to the crime. The actus reus and the mens rea of any offense are embedded and established in any offense where there is confession and plea of guilty to the crime. In fact, where this is the case, the prosecution is left with no burden of proof against the accused person, since all the known and unknown ingredients of the crime have been brought to light by the confession that is positive, direct and voluntary. Whatever came thereafter, from the appellant is a wasted afterthought, that is immaterial in helping him, or proving his innocence. The defense that they thought the officials were armed robbers smacked of no common sense and security. The officials were in their uniform and in fact, the appellants were apprehended at about 8 a.m., which gave enough sight and visibility to the appellants to know that they were not armed robbers. They were only guilty-laden, that is why they did not want to stop for a search of their car. The court is required to conduct trial or hearing of a case with all fairness to both parties to the suit, without bias or partiality in favor of or against either party. The gravamen of the appellant's contention is that the appellants, having given a reason which ran contrary to their plea, the court ought to change their plea of guilt, and to have asked them to seek legal representation, or provide one for him.
Section 36(6) of the 1999 Constitution provides as follows. Every person who is charged with a criminal offense shall be entitled to a. Be informed promptly in the language that he understands, and in detail of the nature of the offense. b. Be given adequate time and facility for preparation of his defense. And c. Defend himself in person or by a legal practitioner of his own choice.
Defending himself in person, or by a legal practitioner of his own choice is an optional condition given to the appellants, but they chose to defend themselves. The legal representation accorded accused person is not a magic wand to secure his acquittal by all means, but that they are not unjustly prosecuted because of the technicalities in criminal trials and proceedings, where the crime has been admitted and confessed to. I do not think that there would be need for any legal representation again. The appellants scrupulously felt that they had committed the crime, and neither God nor lawyer would defend them to afford them an acquittal, hence, they chose the path of confession and a plea of guilt. There is absolutely no unfair treatment to the appellants in this case. The appellants have taken advantage of the constitutional provision to defend themselves in person, and therefore cannot turn around to allege breach of their constitutional right to legal representation or fair hearing. There was no such denial of fair hearing to them by the trial court. Consequently, I dismiss this appeal and affirm the decision of the trial and appeal courts.
Welcome back. I am sure you enjoyed this episode. Surely, you must have learned one or two things from today's episode. Tell me in the comments section. The fair hearing provision under our laws is not a magic wand. You cannot elect to defend yourself in a criminal trial and then turn around to say you were not given fair hearing. However, if the punishment for that offense were to be a capital punishment, the court would have entered a plea of not guilty for them, even though they pleaded guilty. Meanwhile, I hope you will agree with me that criminal activities does not pay. The NDLEA, was established to rid the country of illicit and dangerous drugs. As a patriotic Nigerian, help them actualize that purpose. Please subscribe to my channel, like and share this video so that others will learn, as you have learned. Bye. See you soon.